In the English term and law, we say that you need to have the guarantee to pledge and to take care of the security. Certain sum of money will be bestowed upon the person's death or on the completion of the policy in case of any untoward incident happening onto your property or to your particular system or business. Then the insurance company will come and restore it back to normalcy. Good morning and welcome to the second session, Unit 3 on Commercial Law, where we are going to continue with the contract of indemnity, the second part. Now, the stand in India, why I'm using this word stand in India is because about the indemnity and the insurance factor. So when it comes to the insurance factor, how does the indemnity of contract comes into picture? Now the section 124 acknowledges that only such a contract under indemnity when there is a guarantee to save another person from harm that may be incurred by the actions of the promisor himself or by other person's conduct. Now, it does not cover a commitment to compensate for the loss due to human activity not occurring. Now, look at the statement altogether that has been wonderfully made in terms of the indemnity insurance. Only when the person who is giving the guarantee has the capacity to save from some situation, then the indemnity of contract arises. But if I'm not there in a position to save you, when I'm not able to save myself, then how will I come and save you? So what happens here is that in an insurance company, when they promise you that they will be in a position to compensate you back under given terms and conditions, that means to say very, very clearly that they would be in a position to pay you back as per the terms and conditions. So it's very, very important here that we understand under what terms, under what conditions this is being activated or this is being done altogether. Now, why this is important? Why it matters a lot, first of all, to us? In case when you are committing to somebody saying that I will be able to compensate, that means you should be ready that that money has to be kept aside for a compensation. At the last moment, you cannot come back and say that, sir, I did not know about it, neither I have the money to pay you back. So what we typically try to say here is that the person has the right for himself, where he says that anything that is occurred by the actions of the promiser himself, that is the person who is promising, because of his mistake himself, if some activity has happened or by other person's conduct or by any other external factor occurring, then we are going to talk about the contract of indemnity. Then we are going to talk about the compensatory factors altogether. If it doesn't happen, there is no way it is happening, there is no chances of happening altogether, then what is the big issue all about, or what is the challenges all about? This will become a very big question. This will be a very big stand altogether where people will ask that this indemnity does not even come into picture. So if it is not going to happen, or if it is not in the capacity, if it is not being explained, if it is not being told at all, then the compensation doesn't come into picture. That's why we are very, very clear about it. It does not cover a commitment to compensate a loss due to human activity not occurring, which is not going to happen, which is not possibly under the human philosophy and human psychology altogether. We are not going to come that into picture. We are not going to cover it at all. So that's why the indemnity of insurance matters a lot in terms of understanding. Followed by the United India Insurance Company versus the Aman Singh Munshilal case. This cover note stipulated delivery to the consignor. Now what happened? Moreover, on its way to the destination, the goods that were stored in the godown and thereafter were carried to the destination. When the goods were in the godown, the goods were destroyed by fire. Now, it was held that the goods were destroyed during the transit and the insurer was liable to pay the insurance contract. Now, look into the entire case. The case is between an insurance company and a person. The case is between an insurance company and a person. The insurance company here has taken up the note of covering the goods in case of any damage. Now, how did the incident happen? The goods have to be sent to a particular destination. So what is the goods now going through is that they are going to be stored in a godown and then transported from the godown to some other destination. But while the goods were in the godown, it was incurring a damage because of an accidental fire. But the case was filed in such a way that the goods were destroyed in the transit and the insurer, that is United India Insurance, is liable to pay the compensation. So that was the case that was put by Aman Singh Munshilal, stating that the goods were damaged in the transit and that's why I am holding the insurance company liable in terms of paying back the compensation. Now, under the English law term, the indemnity has been covered under the wider sense of Indian Contract Act, which gives it. Now, what it says that it requires a guarantee to save the pledge from failure because it is caused by human intervention or other such incident, such as an accident of a fire or any other kind of nature. So, what does the English law say is that it requires a guarantee. It requires a complete understanding, trust and a promise saying that at whatever might be the conditions, in case of damage, I 100% go ahead and say that I will go back and pay your compensation. I give you that 100% guarantee that you will be compensated under whatever conditions that I've been told. But here, what is the challenge that is coming is that suppose if the person is not in a position to go forward and give the compensation as that has been told, then what happens? The contract will get completely broken and the person will have the rights to sue the promiser. So that is why in the English term and law we say that you need to have the guarantee to pledge and to take care of the security. Followed by in English law, an insurance contract is an indemnity contract. Nevertheless, the life insurance plan is not an indemnity plan since it has a specific factors in that contract. But generally, when we talk about the general insurance altogether, as per the English law, every insurance is actually an indemnity contract. Let us just understand and analyze that statement for a while. What does an insurance promise you? In case of any damage, in case of any loss, in case of any emergencies or exigency situation arising, then the insurance company will come forward and compensate you. So whenever you talk about a fire insurance, a marine insurance, a theft insurance, property insurance or shop insurance, what does it typically give you? A promise in case of any untoward incident happening onto your property or to your particular system or business, then the insurance company will come and restore it back to normalcy. So that is why, as per the English law, every insurance is actually a part of indemnity except for the life insurance, because that has got certain specific terms and conditions which are already underlying in the insurance. Because in life insurance, please understand that it has been told that your life is covered under particular factors and we are not going to live forever. So there are certain terms and conditions which have been governed there, and that's not a typical indemnity. Apart from that, every other general insurance will come under the indemnity of contract. Moving further, for example, a life insurance policy may include a payment of certain sum of money either upon the person's death or upon the expiry of the defined period. Now, this is a case where the issue amount of the damage incurred by and compensation does not arise altogether. Now, for example, if you say that a person has taken an insurance policy for 20 years or 25 years, after that 20 or 25 years, upon the completion of the policy, the person is eligible to get back the money with the premium, with the whatever interest factors as his benefit. But suppose if the person dies before the policy gets over, and when the policy is in active force, then he is eligible to get a compensation back. That the compensation will go to his family members. So that's why we say that certain sum of money will be bestowed upon the person's death or on the completion of the policy, whichever is the earliest. We are not going to say only on damages, whereas the indemnity of contract comes only into the picture when there is a loss or damage. It is not something like a guaranteed every time that I'm going to pay you an indemnity charges. This is where it differs from that of the life insurance. Now, that is why we say that, however, through a certain sum is due in the event of death, because the person's life cannot be measured. Unlike a property, the entire guarantee amount is due. For even that reason, this is not an indemnity deal. Why? Because life cannot be measured on the same factors like that of a property. Now, when you take a machine or when you take a system or you take an asset like a vehicle, it has got a definitive short-term life period like 5 years, 10 years. So it's measurable. But you never know to what extent human beings can live. You cannot predict the death of a human being. So in that case, in that category altogether, this does not become, that is the life insurance does not become an indemnity contract. Now, the recommendations that have been done by the Law Commission of India. The Indian Law Commission prepared and published its 13th report in 1958 under the chairmanship of Sri M.C. Setalvad, proposing the changes to the various provisions of the Act. Now, what are the modifications that have been told? Modification of privity of doctrine to require the third party to sue the conditions in respect to the contract made to this benefit. So what happens here is that privity of doctrine has been introduced to the third party, saying that in case of any damage, in case of any charges, or in case where you are going to ask about certain factors or certain changes, that means you have to include this to get your benefit done. So the privity of doctrine to require for the third party, saying that yes, I am going to ask for the compensation, followed by change in consideration doctrine to make contracts enforceable. Now, the moment I use the word enforceable, that means it is very much enforced under the court of law without consideration and obligation to hold bid open for indefinite period of time. What does this mean? Stating that, suppose, for example, you give us time to prove for the damages. Don't just say that within an X amount of time period, finish it off. Give me an open time window stating that these are the damages. Give me time for it to prove it with evidence to claim back the damages. So that is why what we try to do here, the consideration factor coming into picture, saying that even without a consideration, we know that this is the contract, this is the damage that has occurred, give us time to get back the money. The recognition principle of promissory estoppels, which means principal promissory estoppel, the person who is involved in this act must be the principal agreeing to all the terms and conditions, wagering contracts and contingent deals to be made unlawful. So any kind of wagering contracts or contingent emergency kind of things will not be considered under the court of law. So it has been told very, very clearly that that will not be considered to be true. to require fair restriction of the right to carry on trade. So it has been told very, very clearly here to require fair restriction of the right to carry on trade. This is important. Why this is important? Now, if you see that whatever activity is being done as a part of the particular contract, to require fair restriction on the right to carry on. So you need to have a fair restriction to carry on the trade factor, which includes rules related to substantive modification of the paper, that's on the documentation part, and the concept of coercion in Indian Contract Act is not exhaustive, because we exactly do not know the meaning of coercion. Is it that he has been done under force, done under influence? So these factors have to be defined even more clearly. So that is why this concept of coercion was again taken into picture and redefined. Now, moving further, it can be referred, that is, see, you on the modern day circumstances where violence can be caused by many ways. Now, coercion is not something exactly where I just threaten you or I just force you. So the Law Commission of India understood that in the modern days, there are many methods or many ways of committing a crime or fraud. There are many ways of threatening a person and getting a work done. So that is why it says that the act of coercion is done by committing or threatening to commit any forbidden act by the Indian Penal Code or unlawful detaining, threatening to detain any property in regards to the prejudice of person whatever, with the intention of causing any person to enter into an agreement. So this is where we bring in the law, where we state that even the intention to detain a property, the intention to threaten a person, the intention to hold the property, the intention of saying that I will put you under unlawful conditions, under some troubling conditions altogether, under some restrictive conditions altogether, by which the person is going to be put under mental state of worry, under mental state of trouble altogether, then we are going to define it as coercion as per the law of India. So what we try to do here is that anything, even the slightest thing which is considered to be unlawful by the court, by the law itself, will be put under the coercion factor. The report suggested the phrase forbidden by Indian Penal Code should be replaced with a wider expressions of offences forbidden by the law in India included in this section. So that is why we bought this coercion in a different way. Coercion is committing or threatening to commit an act. When committing it or threatening such is punishable under the law for the time being in force, or unlawful detaining, threatening to detain, or doing anything with regards to the person who is trying to enter into the contract. So what happens here is that even if you think of doing it, even if you have intended to do it using somebody else, some other means, some other method altogether, yes, you are trying to get into a coercion factor altogether. So it is highly advisable, understandable in nature that you should not get into these kind of activities. Suppose it has been proved even to the slightest manner that yes, you had the option, you went through it in terms of committing, in terms of making the person get into a coercion mode, then that contract will become invalid. With this, I come to the end of this particular session. I hope and believe that all the information that is being shared through this particular session would be of a great help and resource to you. In the upcoming session, we will be seeing more about the commercial law in terms of the rights of guarantees and other factor. But until then, stay tuned, stay blessed, and stay enlightened forever. Thank you once again for joining me today on this wonderful session.